Aye.
Dave?
Aye.
Deb?
Aye.
Shane? And I vote aye also. Motion passes. Do I have a motion to approve the administrative order on consent on Osage Central Weston County?
So moved.
Second.
It's moved and seconded. Let's see, Shane?
Aye.
Deb?
Aye.
Dave?
Aye.
Steve?
Aye.
And I vote aye also. So motion passes. Okay, at this time, we'll begin the hearing in docket 18-4803 in regards to Contura Coal. I assign the duties of the hearing officer to the Office of Administrative Hearings. The hearing officer assigned by Office of Administrative Hearings is Bernard Haggerty. At this time, I will hand the hearing over to Mr. Haggerty.
All right, thank you, Madam Chairman. As indicated, my name is Bernard Haggerty, and we've already had, maybe I should go through this formally. Today's date is May 15, 2019. The time is shortly after 9 a.m. The contested case proceeding will come to order, and we are on the record in the state of Wyoming in the Office of Administrative Hearings upon referral from the Environmental Quality Council in the matter of permit renewal application of Contura Coal West LLC P20214, and in the matter of the applications for coal mine permit transfers of Black Jewel LLC PT0214 and PT0428, OAH docket number 19-004-220C103, docket number DEQ/EQC 18-4803, and docket number DEQ/EQC 18-4805. Good morning, everyone. I think at this point, what I'd like to do is have introductions of the parties so the transcript is clear about who's present. Then we'll discuss any preliminary matters, and then we'll begin with opening statements. So, Chairman Lally, do you think we need to introduce the council members again? Maybe just so that the record in the contested case proceeding is complete. Why don't we do that first, and then I'll have the attorneys introduce themselves and their clients.
Okay, why don't we start and just go across the line?
Sure. Stephen Lenz.
Deb Bomber.
Megan Lally, Chair of the Council.
Is that it for the council members?
That are here at the moment.
All right.
Will join us.
Very good. And as they join us, I assume we can make a note for the record that they've joined us. If anyone has to leave, we can make that note as well. Would the attorneys please introduce themselves and their clients that they have present? And I guess we can start with the DEQ. Go ahead.
Good morning. My name is James Cassidy. I'm the Deputy Attorney General with the Wyoming Attorney General's Office, representing the Department of Environmental Quality, Land Quality Division today. And with me, I have Mr. Kyle Wentland, who is the Administrator of the Land Quality Division.
Good morning, Shannon Anderson on behalf of Powder River Basin Resource Council. And I have with me our Executive Director, Jill Morrison.
Good morning. My name is Jeff Pope. I'm an attorney with Holland and Hart. I have with me Isaac Setfin, another attorney from Holland and Hart, Carrie Speck, one of our paralegals. With me from Contura Coal West, who we represent, is Jill Harrison, the General Counsel, and John Paul Jones, the Vice President for Environmental Affairs.
Good morning. My name is Eric Fry, and I'm General Counsel for Black Jewel. And with me from Black Jewel, I brought Mark Thrall this morning.
Is that it for the parties? I think that's it for the parties, isn't it? I'll just make a note at this time that there's a part of these proceedings that involves confidential documents. And I guess I should have counsel for the council introduce himself too. You want to do that?
Sure. My name is Mackenzie Williams. I'm Senior Assistant Attorney General, and I'm the advising attorney for the county.
Okay, so what I was about to say about confidential documents was when we get to the point in the proceedings where evidence will be presented about those documents, some some of you may be asked to leave the room, and we may have some instruction about non-disclosure. It looks like we have another council member.
Yes.
Is that right? When you get settled, maybe you can interject and introduce yourself.
Sorry about
You want to introduce yourself, just for the record?
Sure. I'm John Cora,
And you're a member of the
and
council.
I am a member of the Environmental Quality Council.
Very good, thank you. Okay, so before we begin with opening statements, I want to invite the parties to address any preliminary matters. One that was brought to my attention was in the pretrial order from pretrial conference that I issued after last week's pretrial conference. I indicated an order of procedure for the evidence, which would be DEQ, followed by Powder River, followed by Contour, and then Black Jewel. And it's been brought to my attention that that should be Black Jewel and then Contour. Did I get that right?
That's correct, Mr. Hearing Officer.
Is there any objection to that general order of procedure?
No objection.
No objection.
I see no objection, so that's how we'll proceed in general. And is there anything else as a preliminary matter that we need to address?
Mr. Hearing Officer, I do have one matter. Shannon Anderson again on behalf of Powder River Basin Resource Council. There are actually two sets of Chapter 11 rules that different parties have cited. These are the rules related to financial assurance. And because financial assurance of the Bel Air coal mine is directly at issue in these proceedings, I'd like the council's review of that issue of which set of Chapter 11 rules are at play. The new set became effective May 3rd, so just a couple of weeks ago. The issue is that it's my understanding that the permit, the renewal permit has already been issued by the department, but the applications to transfer the permits have not yet been issued. So it'd be my recommendation that the old Chapter 11 rules probably apply to the permit renewal, but the new rules apply to the permit transfers. But I'd be interested to hear what the council and other parties think. Just for purposes of talking to you all for the next 2 days, it'd be helpful to know what set of rules we're dealing with.
Before I have the other attorneys answer that, are the rules or any of the rules an exhibit before the
No,
council?
they're not, Mr. Hearing Officer, and normally what we do is we just rely on the Secretary of State's website that is available to everybody because parties and the council members can readily view those rules, and they're the correct version of those rules.
Can you do that with their notepad devices at the hearing, is that right?
That's right, yeah.
All right, well, DEQ, what's your position on that?
Our position with regard to renewal is in fact they're governed by the old version of Chapter 11, and at appropriate points in the course of the proceedings, I think the parties will point out to the council that this is old Chapter 11 versus new Chapter 11. I don't have a concern or problem with the notion that the permit transfer is governed by new Chapter 11, even though it just barely came into effect. DEQ's position will be this complies with both.
Contour?
We take the same position as DEQ, Mr. Hearing Officer.
Black Jewel?
Same here, Your Honor. Thank you.
I should say that I printed out a copy of those rules, Chapter 11 rules, because I don't have a device, and it happens to be the 2019 version, so maybe if I'm called upon to look at them, someone can help me out with a copy. All right, well, is there anything else about that that we need to discuss? Is that sufficiently addressed for the parties?
That's fine, thank you.
Anything else as a preliminary matter?
Nothing from DEQ.
Mr. Hearing Officer, I do have just one other thing for the record. You did mention the confidential aspect of this hearing. I'd just like to note for the record that Powder River Basin Resource Council has a separate proceeding in state court related to the confidentiality of the public record that we'll be talking about. And it is our belief and opinion, and we're litigating it directly in state court, that this document is in fact a non-confidential public record. And I would just remind the council that you are at an open meeting, and you must figure out whether you can enter into some kind of executive session related to that document. So thank you.
Mr. Hearing Officer, if I may on that point.
Go ahead.
The council has entered a protective order in regards to the appraisal, which is the confidential document we're talking about. Yes, the Powder River Basin Resource Council is litigating that issue in district court, but there's been no ruling yet. So I think as far as the council should be concerned on this issue, executive session is not necessary. The parties have stipulated to that protective order, and it governs the mode of proceedings when we're talking about that. I think that keeps it straightforward.
Mr. Hearing Officer, this is an open meeting under the Open Meetings Act. So it is a little different than a regular contested case hearing in that regard. And also note that the protective order was not actually approved by the council. It was signed by Chair Lally, as far as I know, and was not voted on by the council as itself.
All right, well, it seems to me like this is something that can be addressed when we get to the point in the proceedings when we discuss the confidential documents.
Sure, that's right.
Otherwise, I don't think it's really an issue. Am I right about that?
That's right.
So when we get to that point, if you'd like to raise your objections, we can have a discussion on the record about that.
We just wanted to note it for the record, again, because we do not waive the confidentiality or lack thereof of this document. We firmly believe it should be a public record that's open to the public.
All right, any other preliminary matters? I guess I'll note, just for the record, and I think the council, at least the council members present, have a hard copy of this binder that counsel for the department compiled. And what should be in here, as I understand it, and the parties correct me if I'm wrong, are the exhibits that were noted by stipulation of the parties. So these exhibits are evidence. And that council members can look at these documents at their leisure. There are some exhibits that have been marked, but which have not been admitted into evidence, and we'll address them as they arise during the course of the proceedings. Did I get all that right?
Yes.
All right. With that, unless there's anything else, are we ready for opening statements?
DQ is ready.
All right, so that according to our agreed order of procedure, you may proceed, Mr. Kathy.
Thank you, Mr. Hearing Officer. Madam Chair, members of the council, there's a bunch of them. My name is James Cassidy again. I represent the Department of Environmental Quality in this matter. As you know, at issue in these proceedings are two mine permit transfer applications and a mine permit renewal application that was submitted by Black Jewel and Contour Coal West respectively. These applications relate to the Bel Air and Eagle Butte coal mines, which Black Jewel is in the process of purchasing from Contour. The renewal of Contour's permit for the Bel Air mine was approved by DEQ on October 23rd, 2018. However, the transfer of the two mine permits are still pending the outcome of this hearing. The division intends to put on evidence establishing that these applications have been properly processed by the division, that the applications comply with all applicable laws and regulations, and that the objections that have been raised are the product of PRBRC's misunderstanding or mischaracterization of the facts and law governing these permit applications. Ultimately, the division intends to show that the permit transfer should be granted and the permit renewal affirmed. The division will call one witness, the administrator of the Land Quality Division, Mr. Kyle Wentland. Mr. Wentland will testify about his education, training, and experience, and in particular, his 30 years of experience with coal mine permits. Mr. Wentland will explain how the ranch properties that have been accepted as real property collateral were obtained by Contour free and clear of all liens and encumbrances by order of the bankruptcy court. He will explain that immediately after the transfer to Contour of these properties from Alpha, prior coal mining company here in Wyoming, the department obtained the first mortgage on the properties, and that it continues to hold this first lien security interest on the properties to this day. Mr. Wentland will walk through the relevant provisions of the mortgage and demonstrate that the mortgage was properly recorded when it was executed in 2016. He will testify that he approved the appraiser that had provided the appraisal at issue in these proceedings both in 2017 and 2018. He'll explain that once he approves the appraiser, all parties are bound by the fair market value determined by that appraiser. And he'll explain that the reasonable expenses associated with selling the property in the event of a default are included in the bond calculation. He'll also explain that recertification of the 2017 appraisal in 2018 complies with the rules, and that Black Jewel was not required to submit a new appraisal with the permit transfer applications. Mr. Wentland will explain the requirements of the Environmental Quality Act and the applicable rules for renewal and transfer applications, and the procedures department employs when reviewing such applications. In particular, he'll explain how the applicant violator system works, what kinds of violations it shows, And which of the multiple checks conducted by the department matter when determining an applicant's eligibility for a permit? They'll demonstrate that the final ABS checks conducted for these applications show that Contura is eligible for the renewal it received and that Black Jewel is eligible for the transfers that it seeks. Mr. Wentman will further testify there's no basis for the director or the council to find that Black Jewel is disqualified from obtaining any permit due to a pattern of willful violations resulting in irreparable harm to the environment. Ultimately, Mr. Wentman will testify that these applications are complete, technically sufficient to comply with all governing laws and regulations. To do that, we'll be moving pretty quickly through the previously admitted exhibits. Those have been provided to you in the notebook in front of you. I made those, hopefully they're easy to follow. Those exhibits are also available to you on your iPad, so whichever you feel more comfortable perusing, please feel free to use whichever technology you like better. I like paper. By stipulation at the outset of this case, the record has included for quite some time the 3 permit files that issue this action, the renewal file and the 2 transfer files. I hope you've had an opportunity to review those before this hearing. We're not going to go through those page by page. That would be terrible. We're going to talk about a couple of pages that matter. And really, there's only a couple of issues that matter in these proceedings. And the rest of the renewal and permit transfer applications are not relevant to the issues that have been raised here. So I will do my best to be concise, to point you to the documents that matter, and to get through this as expeditiously as possible. The division appreciates the opportunity to demonstrate its thorough and professional handling of these permit applications, and I look forward to putting on our case for you. Thank you.
I was just going to check. Are you checking time then?
I have not been, but I'd like to.
I'm certain I'm under my time.
Yeah, I'm sure you're fine. I'm just saying, we did agree to 10 minutes, so just if there could be a check on.
And we agreed there'd be no minimum time for
Right.
ordinance.
Okay, thank you. Madam Chair and members of the council, good morning. Again, my name is Shannon Anderson, and I'm a staff attorney for the Powder River Basin Resource Council. We are a Wyoming citizen-led organization that focuses on ensuring responsible development of our state's mineral resources and sustaining our quality of life for future generations. Our organization was formed in the coal fields of the Powder River Basin 46 years ago, and throughout our history, we have continued to be the voice of citizens who live near mines like the Eagle Butte and Bel Air mines that issue before you, and we work with the citizens to help them protect their property, quality of life, and environment. I have with me today Jill Morrison, our organization's executive director and longtime community organizer. She's going on 30 years next year with us. Those of you who have been on the council for a while know we don't appear before you often. The DEQ makes dozens of coal mine permit decisions every year, and we leave almost all of them unchallenged. But in rare instances, we come before you because we need your help in ensuring that our laws and regulations are followed. The last coal permit we brought before you is probably fresh in some of your minds, as it presented challenging questions on the scope of DEQ's rules and what standards a coal mine company needs to meet to do business in Wyoming. Like that proceeding, this hearing before you today also brings up challenging questions of first impression for the DEQ and how it regulates, and we need your help in answering those questions. And with that in mind, let's talk through what we are asking you to consider over the next 2 days. Our first set of concerns revolves around something called a real property collateral bond. Perhaps you've never heard of this kind of bond before, and that could be because it's a new addition to Wyoming law. The Environmental Quality Act was amended just last year to add in real property collateral bonds. Prior to that time, these bonds were included in DEQ's self-bonding rules, but the collateral part of self-bonding wasn't ever used because companies could easily qualify for self-bonding without collateral. But after a series of coal company bankruptcies, where companies entered those bankruptcies with only self-bonds to guarantee reclamation work at the mines, including Contura's predecessor, Alpha Natural Resources, DEQ proposed reforms to Wyoming's financial assurance rules that now require a company to have good credit before they are able to exercise the privilege of self-bonding. This council adopted those new rules just a few months ago, and as we just mentioned, they became effective May 3rd. And now, with self-bonding less of an option for some companies, our organization is wary that those companies might start looking to real property collateral bonds. So far, Contour and Black Jewel are the only companies that have used real property for reclamation bonding, but more frequent use could be on the way. It's thus important that we work through the tricky issues now, at the time of their first use, to clarify the rules and processes that the DEQ must use to accept these real property collateral bonds. Over the next 2 days, we'll be talking a lot about an appraisal of the real property used as collateral for the reclamation bond. After being able to review it pursuant to the protective order, Ms. Morrison and I have some pretty big questions about that appraisal and the process used, and ultimately the conclusions reached to value the property. We'll get to those questions when Contour and Black Jewel's witnesses testify, but for now we hope you understand that the value of the real property really matters here. Because if DEQ ultimately has to sell that property, and the property ends up selling for less than the amount of the bond, the agency, and really all of us as Wyoming taxpayers, will have to foot the bill to fill in the gap. We also have some big questions about the process DEQ used to establish its administrative expenses for the bond amount, and what factors the agency considered in evaluating the likelihood and ability to be able to market and sell the property at all. We also have questions about the state's interest in the property and whether and how that interest is protected. We'll get to those questions when Mr. Wetland and Mr. Robb testify here this morning. I realize that bond forfeiture may seem unlikely to you, and perhaps you think we're overreacting to some of these details. Wyoming hasn't had a bond forfeiture at a big coal mine yet, and maybe it's hard to imagine it could happen. But we do have bond forfeitures for small mines. You see those before you. And we all know the coal industry is struggling, and that mines with lower value coal, like the coal at Bel Air, have challenges in today's energy markets. So while this is a hypothetical now, it could be reality in the future. That means the details really matter here. And as I just explained, the details matter not just for Bel Air, but for the future practices of the DEQ in accepting these kind of collateral bonds. We look forward to working with you over the next 2 days to answer the questions and get the details right, with the ultimate goal and requirement to protect Wyoming taxpayers from any kind of cleanup liability for the mine. The second set of concerns we have raised center around a requirement unique to coal mining, which prevents a company that has violations of its current permits from getting more permits. This good operator provision is enshrined in both federal and state law and requires any regulator reviewing a permit application to check the compliance status of the permits at coal mines across the country. The requirement extends not only to the company seeking to get the permit, in this case Black Jewel, but also to any company or anyone who owns or controls that company. The goal of these ownership and control rules is to prevent a loophole where a bad operator with violations that haven't been addressed at other mines could simply form a new LLC with a new name and all of a sudden be eligible to get a permit again. Those ownership and control rules really matter here because according to his filing with the Secretary of State, Black Jewel is owned and controlled by a man named Jeffrey Hoops. Mr. Hoops owns and controls another company called Revelation Energy, along with some other mining companies back east. Mr. Hoops owns a lot of companies and a lot of mines. Now, there is no dispute that some of these companies owned and controlled by Mr. Hoops have violations that show up in what is called the applicant violator system, a database of violations of coal mine permits across the country. This AVS system is run by the Office of Surface Mining, and state regulators like DEQ can enter data. So again, there is no dispute that there are violations that attribute back to Black Jewel. What is in dispute, and what we will be talking about the next 2 days, is whether these violations that are in the AVS database had been corrected or in the process of being corrected to the satisfaction of the regulatory agency that issued them, which is a requirement of Section 406 and Romanet 7 of the Environmental Quality Act. There is an absence of Wyoming law to clarify what conditions must be met or what information DEQ must review for the agency to find a violation has been corrected, and we ask for your review and guidance on the subject. There is also a dispute between us and DEQ on what violations must be included in the permit application. We interpret the law differently and believe that the Environmental Quality Act requires consideration of violations from federal agencies, like the Environmental Protection Agency and the Mine Safety Health Administration, as part of its compliance review. We'll get to those issues and interpretation differences through the testimony of Mr. Wetland and Mr. Robiszewski this morning. Now, you've heard a lot today already from Mr. Cassidy about the scope of DEQ's review and something along the lines of the law just doesn't require this and DEQ normally does this or that. So everything here is the same and it's okay. But we ask you to remember during the course of the next 2 days, the fact is DEQ has never done this before. Prior to Contura, DEQ had never allowed a company to guarantee reclamation obligations with over $26 million in real property collateral bonds. And prior to Black Jewel, DEQ had never allowed a company with dozens of violations in the applicant violator system to obtain a permit. So again, we need your help in getting this process right. If you live near the Eagle Butte or the Bel Air coal mine, I'm pretty sure you'd have the same questions we do. And we hope you can help us answer them. We thank you for your efforts and your time, and we look forward to your participation in these proceedings. Thank you.
Okay, thank you, Councilor Black Jewel.
Thank you. Good morning again, council, counselors, spectators. It is an honor and a privilege to be here to speak to you all today on behalf of Black Jewel. Just by way of unimportant background, I was a litigation attorney for the last 10 years and have been at Black Jewel for about a year. My undergraduate experience as a 2005 graduate from Washington University in St. Louis, where I was a member of the Pathfinder Environmental Sustainability Program and was fortunate enough to study under Raymond S. Arvidsson. It's my pleasure to, after 10 years of litigation, get to use my education a little bit, speaking to you all today. So I joined Black Jewel last March 2018, and in the last year it's been a very, very educational experience working with such a great company. Black Jewel was formed in July of 2017 and purchased several assets from other coal companies. And in December of 2017, Black Jewel had an opportunity to purchase the Eagle Butte and Bel Air coal mines up in Campbell County, Wyoming. Now, y'all will be pleased to know that over the last 18 months of Black Jewel actually operating those coal mines, we've received exactly 0 environmental citations there. It's very important for the hearing and the evidence we put on today, and especially in light of Black Jewel is a bad actor where there are so many environmental citations. I hope to show you through our evidence that's frankly just not the case. Black Jewel has close to 720 permits in the East, and this hearing is about the 2 permits here in Wyoming. I've brought with me 2 witnesses to present to you, maybe later today, definitely tomorrow. I brought the Environmental Manager Senior, Mark Thrall, who is the man who completed the permit application process. He's going to discuss to you what he put in the permit application and go along with what Mr. Whitman's going to testify about the permit application process and about it being technically complete. Also, to help the council here, I brought with me Bob Brockman. Mr. Brockman is a certified appraiser here in Wyoming. He completed the appraisal of the ranches at issue for the land collateral here. He's going to testify and tell you all that the price is more than adequate if the worst were to happen and that the bonds would have to be called to reclaim the mines. We're all here and we hope that doesn't have to happen. I really look forward to presenting to you all these days and really appreciate your time and listening to me. Thank you all so much for your time, and I look forward to presenting to you. Thank you.
Thank you, Mr. Hearing Officer. Good morning, ladies and gentlemen of the council. Again, my name is Jeff Pope, and I represent Contour Coal West. In a rare turn of events, I agree with Ms. Anderson on one big picture point. The details do matter in this case. Unfortunately, the details of this case show that we are not here in an effort to protect the public interest. We are here in an effort to delay the process for the permit renewal and the permit transfers that DEQ has done exactly to the letter of the law. Now, I'm sure that's exactly what you would expect to hear from the coal company attorney, so don't take my word for it. Let's take a look at a public record. What's on the screen now behind me, hopefully y'all can see it, we're going to certainly blow it up for y'all, is DEQ Exhibit number 10. First thing I want to note about this is the date. January 18th, 2018, over a year ago. So why is that important? Well, DEQ Exhibit number 10 is a letter that Black Jewel's representative, Mark Thrall, sent to DEQ in response to some of their questions. Paragraph 3 is particularly important. 2 details should jump out at you here. The first is the statement that Black Jewel intends, once the permit transfers are completed, to replace the real property collateral bonding with surety bonding. meaning the tricky issue that Ms. Anderson just spoke about will become irrelevant once the permit transfers are completed. And Ms. Anderson and the Powder River Basin Resource Council knew or should have known that this was going to happen for well over a year. But despite that detail, we're still here talking to you. The second thing that should jump out at you is the statement that Black Jewel doesn't yet own the 2 ranches used as collateral for the real property bonding provision. Why does that matter? Well, Ms. Anderson alluded to the state's interest in this property and that there are potential problems with it. She is alluding to an agreement that Campbell County and Black Jewel have entered into that places a lien on Black Jewel's property. We believe she's going to contend that that somehow clouds DEQ's first mortgage that Mr. Cassidy mentioned. But as the detail in this letter from over a year ago explains, that's not possible because Black Jewel does not yet own that property. So those details reveal that there aren't really any tricky issues when it comes to the reclamation bonding portion. But we're still here talking to you. If you want more evidence, not from me, take a look at what you're going to hear versus what you're not going to hear. On the bonding side of things, you're going to see the appraisal. The appraisal is going to show you that the property is valued at around $26 million. We're talking tens of thousands of acres of land. You're going to hear about the methodology used in that appraisal. You're going to hear from the appraiser. You're going to hear his qualifications. And more importantly, you're going to hear from an independent third-party expert who Contour retained to take a hard look at the appraisal and see if it was actually sufficient to justify the value. And you're going to hear from that independent third party that there were in fact some problems that required additional substantiation and some potential revisions. But after working with the appraiser, the appraisal now reflects a sound, supported methodology. That's what you're going to hear. Well, aren't you going to hear anything to the contrary? There is not a single witness who is going to stand up and tell you that the appraisal is wrong, that the methodology is unsound. You're not going to see any admissible evidence that says that either. You are only going to hear statements from Ms. Anderson on that point, which I'm going to remind you several times while I'm talking is not evidence. The same thing is very true for the issue about the violations. Details matter here too. I agree on that point. So what are the details you're going to hear? Well, you're going to hear and see the applicant violator system reports that show the violations by Revelation Energy. And you're going to see all of them are listed as conditional when DEQ said that the permit transfer applications were suitable for publication. Why does that detail matter? Well, Wyoming law is very clear on this issue that if the violations listed on an ABS report are conditional, there is no restriction you have to have an outstanding violation. But you're not going to see any evidence that as of the time DEQ made it after Contura sold the Eagle Butte and Bel Air mines to Black Jewel, you will hear from John Paul Jones, the Vice President for Environmental Affairs, that they entered into an operating agreement where Black Jewel has been operating those mines for the last year and a half. And there's not been any violation or any problem. In fact, the only evidence, and I should be careful here, the only statements that you will hear that there are a problem with the permit application or the permit applications for transfer or the renewal applications is from Ms. Anderson. Statements from lawyers are not evidence. I can tell you as a lawyer, it'd be really easy to try a case if what I said counted as evidence. My job would be a lot easier, but it's not. At the end of the next 2 days, you need to hear from a witness or see a document that tells you DEQ made an incorrect decision in renewing the Bel Air permit or in deeming the transfer applications for Bel Air and Eagle Butte suitable for publication. You're not going to hear that. So at the end of the next 2 days, we will ask you to affirm DEQ's decisions for all of the permit applications that are involved in this case. Thank you.
Okay, thank you for your opening statements. Before we proceed with the department's case, I think we should. And I have one other note here. As I laid out the general order of procedure, I didn't mention this, but it also gives you have an opportunity to ask questions. If there's a question that you want to ask of a witness, for example, you are allowed to do. If I forget to ask, feel free to remind me. Okay, so DEQ.
Thank you, Mr. Hearing Officer. DEQ would call Mr. Kyle Leonard.
Mr. Reynolds, would you raise your hand and swear? Do you swear or affirm the testimony you're about to give will be the truth, subject to the penalty of perjury?
Yes, I do.
Okay, thank you.
My name is Kyle J. Wendland, and I'm the administrator of the Land Quality Division.
Can you describe briefly for the council your educational background?
Yeah, I received my bachelor's in 1989 with a focus in disturbed land reclamation. And I received my master's in fire plant ecology from the University of Wyoming in 1993. And for those who are alumni, go Cowboys.
And would you just briefly summarize your work history up to and including your position as administrator?
Yes. After graduate school, I worked for the state of Montana in their coal division as a regulator for 2.5 years. Then I accepted a position with, at that time, Norco and Pacific Corp at the Dave Johnson mine. And I worked for them for 7 years. Then I moved to, at the closure of that operation, I moved to the North Rochelle for 2.5 years. Then I went into financial on my personal business for 5 years. And then was offered a position back with a former Norco sister property at the Antelope Mine with Rio Tinto, and subsequently Cloud Peak for 9 years. And then I've been in the administrative role for the past 4 years.
During the time that you were working for coal companies, mining here in Wyoming, did you have any role in the permitting processes for those entities?
Yes, I did. In fact, I held positions ranging from senior manager level environmental permitting to production through to asset acquisition positions with the companies that I worked for, and have been engaged in as being a lead permittee and now a lead regulator for those entities.
So what is your role now as an administrator as it relates to processing coal permit applications?
I am the regulator in the state of Wyoming for solid and or hard and soft solid minerals in the state.
So what do you do with regard to coal permit applications?
Following our processes, I review and either sign, depending on the requirement of the application, either sign and approve those permits or recommended the director approval or denial of those permits.
And have you been working on one side or the other of the permitting process for 30 years or more?
That is correct.
So you're familiar with it?
Yes, that is correct.
All right. Shockingly, in the materials, in the permit files, what I don't see is map, which is weird because most of your permit files have lots of maps. So I made one for you. I'd like you to turn to Exhibit 14. You don't want to say hi. I can't make it. I can't make it. But I'd like to begin just getting everybody oriented to the location and size of the mines and ranches that are at issue here. So if you take a look at DEQ Exhibit 14, can you tell the council what that is?
Yes, this is a map that depicts the location of the ranch properties that had been pledged as collateral, real property collateral here in relation to the Bel Air line permit boundary.
All right, there's also in this proceeding, the Eagle View line. Where is that in relation to the properties that you can see on Exhibit 14?
Yeah, the Eagle View mine is approximately due north 27 miles of the Bel Air permit boundary.
And the Bel Air mine, where is that in relation to the town of Gillette, which I'm sure folks are familiar with?
It is about 13 to 17 miles south on Highway 59 from Gillette, Wyoming.
And we see the two ranch properties there outlined in green, is that correct?
That is correct.
Can you just give the council a general sense of how big the two ranch properties at issue are?
Sure, the West Ranch property or West Ranch or west of the Bel Air permit there and west of Highway 59 is approximately 17,000 acres and maybe a little change, I believe.
And the southern property there?
Is about 31,000 acres, I believe, and a little change.
All right, so significantly sized properties, correct?
That is correct.
All right. Now I want to turn, I told you we flipped through these. I want to turn back to Exhibit 4 if you can. And that's DEQ's Exhibit 4. And for the folks who are following along in the notebook, the exhibits are arranged in the party order. So DEQ, then Powder River Basin Resource Council, followed by Contour. So when I say most of the ones we're going to be talking into the notebook. Can you take a look at Exhibit 4? And I can tell you're on the wrong one. Flip back to the beginning of the book.
Oh, sorry.
Go to D.
Yeah, Error 4, sorry.
There you go.
Okay.
Can you tell the council what DEQ Exhibit 4 is?
Yes, this would be the first lien mortgage that is associated with the real property collateral.
All right. Can you explain to the council how it was DEQ obtained this mortgage?
Yes, DEQ obtained this mortgage when Alpha was exiting bankruptcy. The land collateral was transferred to Contour via a bankruptcy court order. And that order and subsequent technicalities of that order was reviewed by our Attorney General's office and found to be free and clear as that transfer was made to Contour. And then Contour then subsequently proposed to pledge that collateral to the state of Wyoming. And the Attorney General's office then wrote the mortgage agreement that we have on file for that land collateral.
And was this mortgage executed to your knowledge basically immediately after bringing the properties from Alpha to Contour?
Yes, that's correct.
Let's look at some of the provisions in the mortgage. The first is right on the front page there. When was this mortgage executed?
On the 4th day of August, 2016.
All right. And at the top of the mortgage, you'll see a stamp. You see that?
Yes, I do.
What does that stamp indicate to you?
That's a recording stamp for the county clerk's office,
Which county?
Campbell County.
All right. So is it your understanding that this mortgage is recorded as document number 1025316 in book 3039 of photos at page 296?
That is correct.
All right, let's look at the very last page of DEQ Exhibit 4. At the bottom of that document, is there a stamp from the Campbell County Clerk?
Yes, there is.
Can you tell the folks on the council what that stamp indicates?
That indicates that the county clerk received this document on the 24th of August, 2016.
Does it have some check marks next to some words there?
Yes, it does.
What do those words say?
The check marks indicate that the document was recorded, abstract, indexed it, and then checked, verified that it was in the book as that correct page.
Do you have any doubt in your mind this is recorded with the Campbell County Clerk?
No, I do not.
And do you know whether this mortgage was also recorded with the Crook and Weston County clerks? Because the properties at issue also sit in those counties.
Yes, they were.
Let's look at a couple other provisions. Go back to the second page of the document, section 1.1, please. Section 1.1 is the definitions, correct?
That is correct.
And the third definition there is the definition of the mortgaged property. Would you read that first sentence through the words Exhibit A?
Yes, mortgage property in quotes means all of the mortgager's interests in I, the real property described in Exhibit A.
Exhibit A is an attachment to this mortgage, right?
That is correct.
And that begins on page 14 of Exhibit 4, is that correct?
That is correct.
So if you turn to to page 14, you start to see a legal description, is that right?
Yes, that is correct.
Turn to page 16. We won't go through the long legal description that's provided there. I just want you to look at the narrative sentence or the narrative paragraph at the end of that first set of descriptions and read the first clause.
Yeah, together with all of the grantor's interest in the minerals thereunder, all improvements situated thereon, and all water rights and ditch rights and rights pertaining thereto.
That's fine.
Okay,
I'm really interested in that first part, which is the mineral interest. Does it say together with the mineral interest?
yes, it does.
Will you turn with me to page 25? Down at the bottom of page 25, do you see a similar paragraph that follows the specific legal description?
Yes, I do.
And what does the first line of that narrative say?
Together with all of the grantor's interest in the minerals thereunder.
You see the same language again on page 26?
Yes, I do.
And again, Exhibit A is the legal description for this property that's being secured by this mortgage, is that right?
Yes, that's correct.
So does DEQ have a security interest in the mineral rights on these ranch properties as well as a security interest in the surface estate?
Yes, they do.
All right, let's turn back to section 2 of this mortgage. Section 2 is on page 4, correct?
That is correct.
All right. And I don't want to read the whole provision, although this one's short comparatively. Just the last bit of the granting language that begins, mortgager does hereby.
Mortgager does hereby bind itself, its successors, and assigns to warrant and forever defend the title to the mortgage property unto the department for so long as any of the obligations remain outstanding.
All right. And if you turn the next page to section 3.6, there's a section entitled Covenants Running with the Land.
That is correct.
And I'm not going to ask you to read that, but is it your understanding that all the covenants in this mortgage run with the land and bind successors in interest?
Yes, that is correct.
So is this mortgage binding on Black Jewel when it becomes the owner of these ranch properties?
Yes, that is correct.
All right. Turn back with me to section 3.1. Section 3.1 is entitled Title, correct?
That's correct.
Would you read that section of the mortgage through subsection C for the first two, A and B?
Sure. 3.1 title, mortgager represents and warrants to the department that a mortgagor owns the mortgage property free and clear of any liens, claims, or interests. Upon recordation with the appropriate authority, this mortgage creates valid and enforceable first priority liens and security interests against the mortgage property.
And read the first sentence in section 3.2 entitled First Lien Status for us, please.
3.2, first lien status, mortgager shall preserve and protect the first lien and security interest status of this mortgage.
Are these provisions consistent with your understanding that Contura obtained this property free and clear of all liens and encumbrances?
Yes, that is correct.
And that when DEQ obtained this mortgage, it obtained a first lien security interest in the property?
Yes, that is correct.
Can Contura or Black Jewel change that status on their own?
No, they cannot.
Let's look at section 4 of the mortgage. or 4.1, it begins on page 5, and it's really long. And we will not ask you to read it, but Chapter 11 of the rules provides essentially that when DEQ accepts real property collateral, it needs to secure the right and power to sell or otherwise dispose of the property by public or private proceedings. Is that fair?
That is fair.
And to your understanding, does section 4.1 give DEQ the right to sell this property at public or private proceedings?
Yes, that is correct.
And if we look at section 8 of the mortgage, it's on page 10. Does that section tell folks in all capital letters that DEQ has the power of sale for this property?
Yes, that is correct.
So at the end of the day, does this mortgage contain all of the provisions it's required to under the rules?
Yes, it does.
Was it properly recorded?
Yes, it was.
Is it still in full force and effect such that it's protecting DEQ in the state of Wyoming?
Yes, it is.
Will it stay in effect when the transfer is complete?
Yes, it will.
Is DEQ still the first lien holder?
Yes, they are.
Does it matter if the county or somebody else gets a second lien on this property?
No, it does not.
If you look at both the old and new sections of Chapter 11, in this case I'm referring to Section 3C7 of the old Chapter 11, new Section 5A3G, do the rules contemplate that there might be other parties with subordinate claims in the future, and that therefore those parties must be notified by the applicant of all actions affecting the collateral?
Yes, it does.
So the rules presume or contemplate that somebody might come along and get a second lien?
Yes, it does. Yes, they do.
What matters is that DEQ has the first lien, right?
Yes, that is correct. That DEQ and the state are in first position.
And they have that.
That is correct.
All right, let's talk about the appraisal. We are not going to get into the specifics of the appraisal, so nobody has to leave or do anything weird. All right? The rules, when you accept real property collateral, require the applicant to propose an appraiser and for you as the administrator to approve the appraisal, correct?
Yes, that is correct.
In 2017, when this appraisal was done, did you approve the appraisal?
Yes, I did.
All right. Can you explain to the council how that happened?
Yes, we were sent an email that requested Mr. Brockman as the appraiser in his company, Keyhole Land Company, I believe, can't remember if that was company or LLC, I'm sorry for the record, but Keyhole Land. And I took a look at that initial application and looked at Mr. Brockman's qualifications. I also inquired with Ms. Wickman, who is the head of our bonding group, and asked if she had any interest or anything of interest or concerns that I should be made aware of that maybe I'm not aware of. And following her review and response back to me that she had no further concerns, and then also that Mr. Brockman was in good standing with the Real Property Board in the state of Wyoming, we accepted Mr. Brockman as the appraiser.
Let's look at DEQ's Exhibit 5. Can you tell the council what this document is?
Yes, this is the email chain between myself and Ms. Wickman.
Okay, can you just summarize the contents of this chain of communications between you and Ms. Wickman?
Yes, again, like I said, I made an inquiry to Ms. Wickman requesting her review or her analysis of the proposed appraiser. Her analysis was concurrent with mine, that he met the qualifications, and we therefore approved the appraiser.
If you turn to the second page of that exhibit, there is an email that begins this chain from Mr. Thrall to you, is that correct?
That is correct.
And is this the email that you referred to in which they proposed the appraiser, Mr. Brockman?
That is correct.
All right, let's look at DEQ Exhibit 6. What is that document?
This is an email chain between Mr. Thrall and myself, granting or approving Mr. Brockman as the appraiser for the property in question.
So can you read your very short email to Mr. Thrall of May 2nd, 2017?
Yes, Mark, then I, as administrator, approve of this licensed appraiser.
Is approval by email okay under the rules?
Yes, it is.
Do you have some fancy form you have to fill out to approve an appraiser?
No, I do not.
All right. What was it about Mr. Brockman's credentials that you thought was important in making your decision to approve him?
Mr. Brockman is a licensed appraiser, certified, qualified in Wyoming. In addition to that, he has spent a large portion of his career in rural appraisals. He is an ACA or ACR appraiser, which is an accredited rural appraiser, I believe. And he is, again, meets all of the licensed and qualifications and requirements, is in good standing with the Real Property Board, has 40 years, 4 decades of experience appraising rural ranch property in Wyoming.
Do you have any concern about approving Mr. Brockman after reviewing his credentials?
No, I do not.
Let's talk then about 2018. Did you approve Mr. Brockman to serve as the appraiser in 2018?
Yes, I did.
Can you explain how you did that?
Yes, we were engaged in a phone discussion with Mr. Thrall of Black Jewel
Who's
at the
we?
time, Miss Wickman and I, the head of the bonding group, and they had proposed verbally to us on phone that Mr. Brockman be retained to conduct the appraisal for 2018.
Now, Brockman didn't perform a complete appraisal in 2017. That's the EQ exhibit 15, is that correct?
Keyhole Land Company.
So in 2017, the appraised value of the two ranch, well, let me ask this preliminary question. The appraisal itself that was issued in 2017, did it appraise the surface estate and the mineral estate, or just the surface estate?
It was the surface estate for the purposes of this appraisal.
Okay. And in 2018, the value ascribed by Mr. Brockman in his appraisal of the surface estate was $26,749,000 for both properties, is that correct?
Yes, that is correct.
And so what was his opinion as to the value in 2018?
That the value was the same.
All right. Now, under Chapter 11, when you do a renewal, back in 2018, the applicant doesn't necessarily have to submit a new appraisal, do they?
No, they do not.
In fact, I think the rules require them to let you know if there's been a change in value, correct?
That is correct.
And in this case, there was not.
That is correct.
So is a recertification sufficient for 2018?
Yes, it is.
Now, in 2017 and 18, the department valued the property at the appraised value for purposes of the performance bond. Is that right?
Yes, that is correct.
And what does that mean? Can you explain what that means to the council?
That means that we accepted the land value at the $26,700,000 and changed number at its full value.
So instead of posting a surety bond or cash or some other collateral, you gave, at this time, Contura credit against the performance bond that they're required to post in the amount of $26,749,000.
That's correct.
Now, Section 3 of Chapter 11, this is under the old version of the rules, but the rule is essentially the same. It requires the department to value the property at the difference between the fair market value and any reasonable expense anticipated by the department in selling the property. Am I right about that?
That is correct.
Right. Did the department anticipate an expense in selling the property?
Yes, they did.
Okay, well, how did you account for the expense of selling the property?
We accounted for that. Well, you have to take into consideration the total bond. And the way that the bonding is structured for a coal operation in Wyoming is it's the current disturbance plus 1 year, plus contingencies, plus unknown contingencies. In this case, the unknown contingencies are calculated as a percentage of the total bond and at 5%. And that is $4.6 million and some change in this case. I don't have the exact number in front of me, but so we had a contingency case of unknown contingencies that would cover this expense in the amount of $4.6 million.
Well, let's look at that. Let's look at DEQ Exhibit 7. What is DEQ Exhibit 7?
This is the 2018 Bel Air Mine annual report calculation for their bond, because the bonds are calculated annually for coal permits.
And it's probably a good time to make this clear to the council. The real property collateral, is that for both mines or just one?
That is for just one. It is just pledged to the Bel Air Mine.
So the Eagle Butte mine, how is it posting its bond for reclamation?
It is 100% surety bonded.
Okay, so we're only dealing with one mine, and we have the annual report for that mine in front of us from 2018. What is this report for?
It's the summary or basically the outline of how the bond is calculated and proposed to the agency, and it's based on a guidance document and that's commonly used in the coal industry for those calculations.
What is that guidance document?
It is guideline 12.
So is this the company's math that they go through to calculate their performance bond for the upcoming year?
That is correct. And then the Land Quality Division works through that calculation and verifies that calculation, and then ultimately agrees or disagrees with that number, and then proposes a director's bond letter for the director for signature.
Okay. Let's not go through this whole thing, but let's look at page 9, which is table 1. Got it?
Yeah, got it.
It's table 1 at the top, and it says reclamation bond summary, is that right?
That is correct.
So what are the?
I'm sorry, Council, just so everybody's literally on the same page. We're looking at a page that says RB7 and it says DEQ 7-009.
That's
Is
right.
that it?
Yep.
Okay.
So the Bates numbers down at the bottom indicate first the exhibit number, in this case DEQ 07, and then the page number of the exhibit. And some of these documents, the internal pagination on them is not consistent. So it might, particularly with the appraisal, if you look at the numbers that are on the appraisal itself, they're out of order in some sense. They start and they stop. The numbers that we put on there are sequential, so they're easy for us to refer to in these proceedings. I hope. If anybody gets lost, tell me. I'll stop and go back. But I'm trying to be efficient. So.
These are the various major categories that are the costing or total costings of the bond, where they summarize that to get to a total cost.
So in Roman numerals 1 and 2 entitled the area bond and the incremental bond, is this the estimated actual cost of reclamation for the work that's been done and the work that's proposed to be done during the upcoming year?
That is correct.
This is the cost of moving dirt.
That is correct.
All right. Now, beyond Roman numeral 2, you see an entry for contingencies, correct?
That is correct.
There's miscellaneous items and unknown costs.
That is correct.
What are miscellaneous items in the amount of $18 million?
Those are line item items that are known to be an expense, and they are on a separate table, and they are segregated from the unknown contingencies.
And are these mostly related to miscellaneous items for moving the dirt and conducting the reclamation?
Yes, that is correct.
Unknown costs is different from that.
Yes, that is correct.
What's unknown costs?
Unknown costs are for unknown or unanticipated or necessary expenses At the time, the bond would be forfeited and needed to be claimed on.
Now, how are unknown costs calculated?
They are 5% of the total.
In this case, the total, is that the total of the area bond and incremental bond reported here at $93.5 million?
I believe that is correct.
So 5% of $93.5 million is $4,676,900.
That is correct.
What do you think the cost to selling these ranch properties would be?
Based on my experience in acquisitions over the years, between 3 and 5%.
What is that, 26 million?
Around 1.2 to 1.6 million. Even if, in this case, you were to use a 10% valuation for disposal of the property, it would only consume 2.6 million of the unknown contingencies.
Is 4.6 million more than enough to pay the expenses associated with selling the property?
Yes, it is.
Do you think it would be fair or unfair for the company to pay both the unknown costs and then reduce the value of the property at the same time?
It would be unfair. It would be essentially be double dipping for that same cost or expenditure.
And is that how you did that in this case? Is this your thought process when you valued this property in 2017 and 2018?
Yes, that's correct.
Now, DEQ also has a security interest in the mineral rights. So do you think DEQ has more security than DEQ gave the company credit for?
Yes, I do, because there are known coal, oil, and gas assets underneath this property.
Right. Do you have any doubt in your mind that DEQ has sufficient security for that portion of the performance bond secured by this mortgage?
No, I do not.
And that's true even with the cost of sale.
Yes, that is correct.
All right, let's talk about what we know about the appraisal from these proceedings. I think you've seen in the exhibits that based on Mr. Sherman's review of Mr. Brockman's appraisal, they've discovered an error in the original appraisal that makes about a $600,000 difference in the fair market value. Is that right?
Yes, that is correct.
Are you concerned about DEQ's security as a result of that error?
No, I am not. Again, the unknown contingencies would more than cover that in the event that that disparity were ever to be realized.
Now, isn't it true that the appraisal that we have for 2017 and the recertification in 2018, is there another one coming?
Yes, it is in process and due in June.
In June. So does it make a difference to you that this mistake that we've learned since the initiation of this case will be presumably remedied by the next appraisal?
That's correct, and I'm comfortable with that.
That's next month.
That's correct.
Have you heard how that one's going to come out?
I have not. I don't have any information to me that would indicate that it's less. My estimation, or based on my 30 years of experience in property valuations, is it's probably going to be more.
Now, that new appraisal that's on its way, is that part of a renewal process or part of the pending transfer process?
Part of the pending transfer process. Excuse me, renewal process. Got that backwards. Sorry.
Okay. Is it typical for Bel Air that they have to go through this renewal process every year?
For the appraisal, yes. Or, under the old rules. Under the new rules, it's every 3 years.
Okay. But they're going to do one for next year in order to renew the existing permit that Contura currently has.
Yes, that is correct.
All right. You didn't ask Black Jewel to get an appraisal when it submitted the transfer application, though, did you?
No, I did not.
Why not?
We already have an appraisal that is current and on file, and there's no known material changes to that appraisal or land that would indicate the value has changed.
When an applicant comes in and gets a permit transferred to them, do they step into the shoes of the previous permittee?
Yes, they do.
So do they get to rely on the previous appraised value until the next renewal period?
Yes, that is correct.
All right. Let's talk about the renewal and transfer process itself. Can you tell the council what DEQ Exhibit 1 is?
catch up to you here. Yes, Exhibit 1 is the coal permit renewal for the Bel Air mine.
Okay. And we're not going to look at anything in particular right now. I just want to get everybody oriented. That's the permit renewal file. What is Exhibit 2?
Exhibit 2 is the permit transfer applications for the Bel Air mine.
And Exhibit 3?
Is the permit transfer applications for the Eagle View mine.
Okay. And in addition, is it fair to call them the applications, or is it the file, or how do you refer to them?
These would be the applications and are currently on record in the file.
Everything in there is part of the application?
Yes, it is, I believe.
Okay. Now, you've looked through before today, Exhibit 1, 2, and 3, correct?
That is correct.
Is there anything unusual about the contents of these applications?
No, there is not.
Have they been processed like any other renewal or transfer?
Yes, they have.
Now, does every document that might relate to a company or a permit renewal or transfer make its way into one of these files?
No, it does not. There are internal discussions and internal communication between staff that would be in draft format that would not be final. The final documents are what make the record.
And is it true that every single email that might mention Contour or Black Jewel might not be in that file?
That's correct.
And we're going to have some later on that we're going to talk about that aren't in the file. Is it unusual for there to be documents talking about a permit application that don't make their way into the file?
No, it's not unusual. Some of that can be deliberative.
Can be what?
Deliberative?
Do these documents, DEQ Exhibit 1, 2, and 3, contain the necessary documents to grant the renewal and transfers?
Yes, they do.
All right. Now, part of the renewal and transfer process is checking into the company, right?
Yes, that is correct.
And so we're going to talk about the applicant violator system. Both the Environmental Quality Act and the Surface Mining Control and Reclamation Act require information about applicants' violations before permits can be granted, renewed, or transferred. Is that right?
Yes, that is correct.
And everybody agrees, you have to look at it, and that you can't grant a transfer under certain circumstances, but you can under others, right?
Yes, that is correct.
Depends on what it shows.
That's correct.
So what is the applicant violator system?
The applicant violator system is a national database that is supplied by the Office of Surface Mining that indicates environmental violations for coal operators across the country.
And who runs that?
The Office of Surface Mining and Reclamation and Enforcement.
Do you know where it gets the data for these reports?
The data is entered by the various regulatory authorities, and OSM also verifies that.
Okay. So you, to get the nomenclature right, you guys run an AVS check, correct?
That's correct.
How do you do that?
I have staff assigned that is registered to access the system and run those verification checks.
What does that mean to run a check? What do they do?
They go into the computer system of OSMRE and type in the coal operator's name or the executive officer's or corporate tree, as it's referred to oftenly in coal permitting. And they run a search to see what that would display as far as violations that may be out there.
And the reports can show information about not just the company you might type in, but also those other entities that are under common ownership and control, correct?
That is correct.
And who decides what entities are under common ownership and control?
That would be through the system with the Office of Surface Mining, Reclamation, and Enforcement.
So you type in the name of the company, you get a report from OSM's AVS system,
That is correct.
right? What kinds of violations show up on this report? What kinds of things can a company do to show up on this report?
It's a wide range of violations that can show up on the report, and it depends on the individual state's regulatory authorities and rules and regulations, but it can be something as simple as filing a report late to something more significant, such as maybe a cessation order or an order of consent decree.
Does the AVS report show mine safety violations?
No, it does not.
Does the Land Quality Division have any jurisdiction over mine safety violations?
No, we do not.
Who does?
That would be the Mine Safety and Health Administration and the State Mine Inspector.
If an applicant has a violation somewhere in the United States, and it's reported in the system as either an outstanding or a conditional violation, correct?
Correct.
Can you explain what the difference is between a violation that's reported in the AVS system as outstanding versus one that's reported as conditional?
Sure. An outstanding violation essentially boils down to it has no abatement. There's no resolution that's been agreed to between a regulatory authority and the company or corporate tree entity. A conditional violation means that there is some level of resolution in that process. And that resolution can range from anything from they've paid a fine, or they've agreed to a compliance plan or some order, or there may be an appeal related to a violation, and that's a process that's provided to an operator and the regulatory authority.
The status of conditional or outstanding in the AVS system, is that determined by the regulatory authority that issued the violation?
Yes, that is correct.
And do they report that to OSM?
Yes, they do.
So when a violation is identified as conditional, that's the determination of the relevant regulatory authority?
Yes, that is correct.
All right. We're going to look at some of those reports here in a bit, but right now I want to look at DEQ Exhibit 8. What is DEQ Exhibit 8?
DEQ Exhibit A is the AVS Office User Assistance Liaison. It's basically their handbook or guidance document.
This is terrible guidance if you read it, isn't
It is.
it? But who publishes it?
The Office of Surface Mining, Reclamation, and Enforcement.
Does it define the terms conditional and outstanding and what they mean in the AVS system?
Yes, it does.
What page does it do that?
It does that on page 4.
On page 4, there's a term defined there called conditional violations, correct?
That is correct.
Will you read that definition?
Yes. Any violation in the AVS is listed as either outstanding or conditional. Outstanding means the violation is unabated or uncorrected. Conditional means that based upon an agreement or other circumstance, the violation may not cause the state with jurisdiction to immediately determine permit ineligibility. This is the person to call to check whether or not the violation is still considered conditional.
So is it your understanding that if there is an outstanding violation, the permit applicant is not eligible to receive a permit?
Yes, that is correct.
Is that commonly referred to as a permit block?
Yes, that is correct.
Is the same true for a conditional violation? Are they eligible or not?
A conditional violation is eligible for a permit.
Now, this language that you read, and I'll grant you some of it's worded goofy, but that's the way the feds write things. When it talks about a conditional violation and what that means, does that meet the requirement in section 406 and 7 of the Environmental Quality Act that the applicant show that any violation has been or is in the process of being corrected to the satisfaction of the authority, department, or agency which has jurisdiction over the violation?
Yes, that is correct.
So these things are consistent with each other.
Yes, they are.
All right. When do you run an AVS check during the process?
We typically run one early in the process, and then, to see where things stand. And then during the process, and then usually right before, typically right before we do signature, either the day before or the day of.
Can you run it anytime you want?
Yes, we can.
Do you sometimes do that?
Yes, we do.
All right. Now, how do checks get initiated?
I ask for that to be done. I direct staff that is authorized to be on the system to run that for me.
do the permit coordinators or district supervisor, can't remember Mr. Rogoshevsky's
Yeah,
title.
supervisor.
Do they have the authority to ask for those as well?
Yes, they do, but that decision lies with me.
Okay. Who physically runs the check?
That would be the staff that's assigned and authorized to be on that system. We have to have someone who's registered with that system. And in this case, I have Miss Vanessa Ramirez and Miss Karen Quigley, who has joined the staff that are authorized to be on that system.
Okay. So they type the information into the system and generate a report?
That is correct.
Do you know what they do with the report?
Then they bring that report to me for my review.
And are you the only person responsible for reviewing the check and deciding whether the applicant is eligible?
Yes, that is correct. That responsibility resides with me.
Do you have to conduct a separate investigation of the violation status listed in the report?
No, I do not.
Does it make sense that you would duplicate OSM's work?
No, it does not.
Why not?
We rely on in our agreements with OSM, they are the oversight and the regulatory agency, senior regulatory agency. And not only do we rely on that, but we also coordinate with their staff on many of these issues.
So do you know whether OSM thinks you have to conduct an investigation over and above the AVS report?
No, they do not.
Now, during the permitting process, you might run this report several times. Are applicants allowed to correct or abate their violations during the process?
Yes, they are. The AVS is a snapshot in time. And it, as anybody knows, you have permits that are dynamic and moving. That is a reason why we run multiple checks.
Does it happen often that applicants might correct an outstanding violation before the end of a permitting process?
Yes, that's correct.
So which AVS check in the process matters for determining a permit applicant's eligibility?
The most recent final check, the one we usually do before we sign.
So if there is an outstanding violation early on in the process, does it determine for all time the eligibility of the applicant?
No, it does not.
Sometimes if you see an outstanding violation on an AVS check, do you talk to the permit applicant about that?
Yes, we do, because we have found errors in the database, and it is important to make sure that information is clear, accurate, and correct, and therefore it is not uncommon to inquire with the operator.
Let's look at DEQ Exhibit 9. What is that document?
That's a document that I wrote a letter I wrote to Mr. Mark Thrall of Black Jewel LLC, indicating to them that they had outstanding violations and that at this time, until they could get them to a conditional status, we would be unable to move forward, I believe.
So you did the AVS check that's attached as pages 2 through 3 in Exhibit 9, correct?
That's correct.
You did that on January 16th, is that correct?
That's correct.
And on that same day, you wrote Mr. Thrall a letter and said, you got a problem, buddy.
That's correct.
Let's look at the AVS check, just to get everybody familiar with what they look like and what kind of information they have, all right? Recognizing this one is early in the process. So where do we see the name of the entity that you're requesting information on?
It would be on the left-hand side there, second column. Sorry, my copy is really difficult to read.
Look in the top right-hand corner.
Oh, I'm sorry. Yeah, Black Jewel LLC, in this case, under your entity header.
Right. So at the top, it says entity name, and it lists the company, and that's who you're asking for information on. Is that correct?
That's correct.
All right. Then below that, you'll find the results.
That is correct.
And in this case, it noted 46 violations, right?
That is correct.
And we'll see in the second to last column, or the second from the right column, it says either outstanding or conditional related to some of those violations, right?
Yes, that is correct.
So that's where we look to see whether or not the AVS check is clear.
Yes, that is correct.
All right. Now, I see that the first company here is not Black Jewel. It's a company called Revelation Energy LLC, right?
Yes, that is correct.
And on the second page, after seeing a bunch of, a long list for Revelation Energy, we see a list for Keystone Industries LLC as well, too.
Yes, that's correct.
Why are those companies showing up in a search for Black Jewel LLC?
Because they are subsidiary or sister companies of Black Jewel LLC.
So their violations matter for purposes of permit eligibility for Black Jewel.
Yes, that is correct.
Do they matter for eligibility for Contour?
No, they do not.
Those companies aren't related at all?
No, they are not. They're separate separate entities, separate companies.
All right. Now, let's turn to the next exhibit, DEQ Exhibit 10. What is that document?
That is a letter from Mr. Mark Thrall of Black Jewel to me indicating that they have looked at and addressed the violations, that they are now conditional status in the ABS.
Okay, so 2 days after you wrote your letter, Mr. Thrall wrote you back and said, "We're good."
That is correct.
I want to turn then to DEQ Exhibit 11. And this is another ABS check, correct?
That is correct.
All right. Can you tell the council who this check, what entity is this check on?
This check is on Black Jewel LLC.
All right. So same company, what date was this run?
On October 4th, 2018.
All right. And again, we see entries for Revelation Energy. And on the third page, we see Keystone Industries LLC, correct?
Correct.
So the same two companies are showing up as under common ownership and control with Black Jewel.
That is correct.
Even though this is 10 months later.
That is correct.
Now, down at the bottom of the third page, there's this narrative information under a heading shockingly called narrative.
That's correct.
What is that?
That's a narrative that relates to the run of the ABS check and some specific linking entities.
And that information can be requested from OSM, is that right?
That is correct.
So in addition to just a straight list of entries, you can also ask for more information from OSM if you want.
Yes, that is correct.
And in this case, it appears you did so.
Yes, that is correct.
And just for the council's edification, when that narrative is printed in the report, it comes from a requester. In this case, I think it's always Danny Brown, and he works for OSM. Is that right?
Yes, that is correct.
Danny Brown doesn't work for you.
No, he doesn't work for me.
So now this check on October 4th is right before the determination was made with regard to the transfers that this should go out to publication because it was technically sufficient, right?
That is correct.
And we know that by looking at DEQ exhibits 12 and 13, correct?
Yes, that is correct.
What are those two exhibits?
These are the letters or documents that say that those two permit applications are ready to go to public notice.
And what date were those letters signed?
October 5th, 2018.
Both of them?
That is correct, I believe. I gotta look on the signature page here, but yes, that's the date on the letters.
Now that letter comes from Mr. Rogaszewski, who's the supervisor for District 3, correct?
That is correct.
Does he do that before you tell him to?
No, he does not.
Okay. So let's go back to the ABS check on October 4th. Is this the one that matters for determining permit eligibility for Black Jewel in these transfer processes?
Yes, that is correct.
Does it matter what any other prior version said?
No, it does not.
All right. Now, what does this ABS check show with regard to the violation status for Black Jewel and its affiliated entities?
That they are all conditional.
Sorry, Council, can you refer me to the exhibit, this particular exhibit you're looking at? Was it 11?
Yes.
Thank you.
They're all conditional. How many violations are on here?
I'm looking for the listing here of the report.
At the top.
Yeah, 42 violations.
Is it unusual for a company to have more than one violation or notice of violation?
No, it is not.
Okay. Has DEQ approved permits in the past? I heard this in the opening and want to make sure we get it. Have you approved permits in the past where the applicant had conditional violations at the time of approval?
Yes, we have.
Is it normal to do that?
It would be a normal course of business if it was conditional status.
So this isn't the first time you've done this?
No.
Okay. So given that all of these violations are identified in a conditional status by OSM, is Black Jewel eligible for a permit as of October 4th, 2018?
Yes, they are.
And is that why the letter went out saying that it was technically complete and ready for publication?
Yes, it is.
Now, that's probably not the end of the inquiry. If the council makes a decision in this case that the permit transfers should be granted, will DEQ run a new ABS check right before the permit is actually transferred?
Yes, they will. We will definitely do that. There's no way I would recommend to the director, and that's a director level signature, that he sign that document without a clean ABS.
All right, so you're waiting to do the very final ABS check to the day before you sign off on the permit transfer. Is that fair?
Yes, that is correct.
Is that normal?
Yeah, that's correct.
Now, there's a provision in the rules under Chapter 2, Section 2, that says an application shall contain a complete statement of compliance. Is that correct?
Yes, that is correct.
Now, there's two parts to that statement of compliance that are outlined in the rules, one under subpart A, and that deals with suspensions, revocations, and forfeitures. And then there's a subpart B, and that deals with notices of violation. Is that right?
Yes, that is correct.
Does Black Jewel have any suspensions, revocations, or forfeitures?
No, not that we are aware of.
All right, so really, we're looking at a statement of compliance related to notices of violation under subpart B, right?
That is correct.
All right. Is that the AVS report?
Yes, that is correct.
All right. Does the AVS report contain the information required by the subpart?
Yes, that is correct.
Who puts that list in the application?
We do, the Land Quality Division.
Does the rule require that the applicant has to put it in there?
No, it does not.
All right. Is there an advantage to using the AVS report rather than relying on a company to self-report?
Yes, there is. That's a third-party independent evaluation.
Do you trust OSM?
Yes, I do. And in fact, I coordinate with OSM.
All right. And with regard to this October 4th, 2018 AVS report, did you talk to OSM about whether this applicant was eligible to receive a permit?
Yes, I did. I had discussion with OSM staff that to verify that in fact, is there something that we are not aware of or should be aware of before granting this action?
And what's OSM's position?
No, there was not.
So from OSM's point of view, are you good to go with these transfers?
Yes, that is correct.
All right. Now, this October 4th report that I've identified as Exhibit 11, I've done that because it's not in Exhibit 2 or 3, is it?
That's correct.
All right. When you run the final report, right before you sign off on the transfer, is that in Exhibit 3?
Yes, it will.
And once that's in there, will that satisfy the requirements of Chapter 2, Section 2, that there be a complete statement of compliance?
Yes, it will.
And is that normal course?
Yes, it is.
Now, there are 42 violations listed on this report, correct?
Correct.
Does it matter for purposes of determining eligibility, how many conditional violations are on an ABS report?
No, it does not.
There could be one or there could be many, doesn't matter to you.
That's correct.
If they have one outstanding violation, however, are they eligible for a permit?
No, they are not.
Now, because there are these multiple conditional violations identified on the ABS report on October 4th, does that demonstrate a pattern of willful violations of such nature and duration with such resulting irreparable harm to the environment as to indicate reckless, knowing, or intentional conduct?
No, it does not.
Why not?
That's a very high bar, and it would be if they were not willing to abate these violations in some form or fashion and come to some agreement or meaningful way to move forward in concluding or somehow resolving the violation, they would have never sought to resolve them to a conditional status. And in this case, the company immediately went in and resolved those issues to conditional status.
Does this look like a company that's playing by the rules?
Yes, it does.
Has Black Jewel or Contura had any violations in the state of Wyoming since they've been doing business here?
No, they have not.
Are they a responsible operator in your experience? Both of them?
Yes, they are, as of this point in time.
Have you seen anything in the course of this case, outside of this report even, anything that would lead you to conclude that Black Jewel has a pattern of willful violations causing irreparable harm to the environment?
No, I have not seen any final court competent jurisdiction that would indicate that they have made that type of an action.
Have you seen anything else in this court determination?
No, I have not.
Let's look on pages 129 and 131 of DEQ Exhibit 1. This is the only time we're really going to go through the permit file, and it's just 3 pages. So we'll be fast.
Can you repeat the pages, Council?
Exhibit 1, which is the renewal application on pages 129 and through 131. And those are the DEQ date stamp numbers down at the bottom. All right. What is this document?
This is an ABS run for a Contour Coal West LLC.
So different company.
That's correct.
When was this ABS check run?
This was run on the 20th of August, 2018.
And what does this one show?
This one shows that there are, this was run and it shows some outstanding violations for Revelation and I believe Keystone Industries, and no violations for Contour.
So the applicant name identified at the top of the report is Contour Coal West, correct?
That's correct.
So why are Revelation Energy and Keystone Industries showing up on this report?
At the time, they are entities that are associated with the report, and in the narrative, I think it clarifies. I'm looking here. Been a while, but anyway, the entities, because we're in that transition of the permit transfers and the renewal, the report was run to look at all of it.
Okay. So at that point in time, had Black Jewel sought a license to mine for the Bel Air mine?
Yes, they had.
Okay. So is it unusual for some other company that's got some a license to mine or some other documentation linking it to a mine to show up in an ABS report?
No, it is not. And that might be important for the council to understand in that process of any time there's an action going on to move a permit from one entity to another. There is, in Wyoming, there is a license to mine that basically allows them to be a contractor to whoever the current operator is. And that holds the permits. And the permits don't transfer until the permit transfer application and the bonding solution as part of that all is in place and can be done. So there's 2 parts of that. So once you enter into that point where you have that license to mine, it's not uncommon to see all of those entities in a search.
They show up on the same report.
Correct.
All right. Now, do you care for purposes of granting Contour's renewal what the status is of Black Jewel's violations?
No, I do not.
Are there any violations for Contour or any of its related entities on this ABS report?
No, there are not.
Let's turn back just a couple of pages to pages 122 and 123. 23 in Exhibit 1. What is that document?
That is the document to Mr. Mark Thrall approving the renewal for Contour Coal West.
What day was that issued?
October 23rd, 2018.
All right, and the AVS check we just looked at was dated August 20th, 2018, was it not?
That is correct.
I'm pretty sure you said that right before you sign one of these approval documents, you run an AVS check.
That's correct.
Did you do that before signing this approval?
Yes, we did.
Where is it?
We are unable to locate that document, and we believe it has been misfiled. At the time, we had 2 staff in transition, and we were in the middle of moving these permits from paper to digital, and it could have very well have been me who has somehow misplaced or misfiled that one particular document.
Well, fortunately, your rules say you got to have one in there. right?
That is correct.
That's what Chapter 2, Section 2 says. You must have a complete statement of compliance, does it not?
That is correct.
All right. So you believe you signed it, but you don't have it.
That's correct.
So we have an August 20th AVS check in the file.
Yes, we do.
All right. Is that sufficient to grant this renewal? A check that was done on August 20th.
Yes, it is.
Is there a law, is there a statute or rule that precludes you from using the August 20th AVS check because it's too old?
No, there is not.
Is there a standard operating procedure? Recognizing, of course, that standard operating procedures aren't binding. But is there one for renewals that says an August 20th AVS check is too old to grant this renewal?
No, there is not.
So does the August 20th AVS report satisfy the requirements of the Environmental Quality Act and your rules that the permit renewal application can contain a complete statement of compliance?
Yes, it does.
And I know we went through that rather fast, which I hope that you're thankful for. But having gone through these files in more detail than we have today, and having reviewed all the exhibits in this case, are all 3 of these applications complete?
Yes, they are.
Are all 3 of these applications, do they meet all of the applicable statutory and regulatory requirements?
Yes, they do.
Should they be granted or affirmed by this council without any modification?
Yes, they should.
And are you completely certain that DEQ has adequate security for the real property collateral that it received?
Yes, I do.
I have no further questions.
All right, before we go to the next stage of the proceedings, I've had a request for a break. So unless someone objects to that, we're gonna have I don't know how long you want, 15-minute restroom break. Is that okay? So we'll go off the record. anybody not here? Does anyone have any questions? We need to shut this door. Okay. Here it is. Okay. All right, is there any reason we shouldn't go back on the record? Very good, so let's go back on the record. We were just finishing the department's direct examination of the witness. And I didn't say this in the order of procedure that I discussed at the beginning, but I'll say it now. I think what would be most efficient is if we have all the attorneys completely examining the witness, and then if council members have questions after that, that would be an appropriate time for those. I don't want to suggest that you can't interrupt and ask a question, but I think the most efficient thing will be to have all the attorneys finish their questioning round one, and then the council members ask questions. So that way, if you have questions, they may get answered in the course of the questioning. So, Mr. Cassidy, you were done?
I am to the department rests.
Okay, all right, that's good. And you're still yours, sir?
Yes, sir.
And Barbara, any
Okay,
questions with?
thank you. And good morning, Mr. Rutland, thank you for being here. I have a preliminary question. In preparing your testimony today, did you meet or confer with counsel for either Contura or Black Jewel?
No, I did not.
Okay. So let's start off with the real property collateral bond approved by the department. So it's just stated that you received this appraisal that was performed by Mr. Brockman, right?
That is correct.
Did you personally receive it? It was delivered to you?
It was delivered to our bonding group, Ms. Wickman, who is head of that group. And I should clarify for the council, in 2016, the agency combined all of the bonding functions under one group within the agency for efficiency reasons and consistency reasons. Ms. Wickman is the head of that group.
Okay, so she received it and then she delivered it to you?
I came to her office to review it in her office.
Okay, and then after you received it, what did you do with it? Did you read it?
Read it.
Okay, did you do anything else with it? Did you share it with anyone else at DEQ or?
No, I did not.
Okay, so just you and Ms. Wickman have this document?
That's correct.
have
It's held
seen it.
confidential right now.
Okay.
Until such time we have a hearing or a ruling on the public records case resolving around that appraisal.
Okay, did Ms. Wickman also read it?
Yes,
You
she
know?
did.
Okay. And you talked about it with her?
Yes, we coordinate on all of the bonding actions related to land quality because she is the head of that bonding group.
Okay, so when you were talking to Ms. Wickman, did you compile or prepare any questions back to Mr. Brockman after both of you read this appraisal?
No, we did not.
Okay, did you instruct any other DEQ staff to compile or prepare questions for Mr. Brockman?
Ms. Anderson, as discussed before, that appraisal is confidential and no, there was no other staff involved.
Okay, so why didn't you prepare any comments or questions for Mr. Brockman after you read that appraisal?
As we read the appraisal and we looked at the valuation, we had no question or concern with the work product as it was completed.
Okay, what if you would have had a question or concern?
We would have taken that question through at this point in time with Contura and Black Jewel to see and routed it through the company back to the appraiser.
Okay, I think your counsel in his opening statement said that once you receive this appraisal, there's a number in it and you have to take that for face value. Is that correct?
Ms. Anderson, if we had questions, as you proposed that theoretical, if we did not, and yes, we did take the number as face value because I don't have an appraisal certification.
Okay,
In the state of Wyoming.
so no matter what the value contained in that appraisal is, it's your contention the DEQ has to use that to establish the fair market value for the property.
That is correct.
No
Because
matter what it says.
that is a certified, qualified appraisal in the state of Wyoming. I am not authorized, nor do I have the certifications to challenge that.
Okay, so we're dealing with roughly 48,000 acres of property, right?
Correct.
So if that appraisal is off $1, that's $48,000 that's off, right?
Again, Ms. Anderson, theoretically, yes, that's correct, but that's not relevant here because in the appraisal that we received, it's from a credited appraiser in the state of Wyoming.
And appraisals can't be wrong even off a dollar?
Ms. Anderson, I'm not saying they can't be wrong, but I'm saying for the purposes of this exercise, that I am not in a position to challenge that number.
Okay, what if the appraisal came back to you and said the property was $10 an acre? What would you do?
Ms. Anderson, that's a theoretical question again, and I'm going to go back to say we received an appraisal from a qualified and certified appraiser in the state of Wyoming with 40 years of experience. And we used that value as that appraiser provided.
Okay, so you're saying an apartment in that situation would never question the value of the appraisal. You don't have that authority, or you just wouldn't do it?
Ms. Anderson, we don't have the authority, nor do we have the professional expertise because we are not certified nor qualified appraisers.
Okay. Is it your opinion that you could send questions back to Mr. Brockman, maybe not about the amount, but about other findings in the appraisal?
In Ms. Anderson, in a theoretical sense, if we had those questions, we would route them back through the company to the appraiser.
Okay.
Because the company owns the appraisal.
Okay, so you'd route them back through Contura, and then Contura would give them to Mr. Brockman?
That would be the route they would take.
Okay, and then presumably Mr. Brockman back through Contura would answer those questions?
That would be the route I would expect those to take because of the ownership and the confidentiality related to the document.
Okay. So in deciding this conclusion that you have to take this value at face value, how did you come to that conclusion that you don't have the authority to question that value?
There's nothing in the rules and regulations nor in the qualifications that I or my staff have to question that.
Okay. Did you talk to any counterparts in other states that run regulatory agencies like you do that accept collateral bonds to see what their practices are?
Ms. Anderson, no, we did not confer with other states. We conferred with our counsel and our Attorney General's office on these matters.
Okay. Did you talk with anyone at the Federal Office of Surface Mining about their standards and requirements for setting the amount of a real property collateral bond?
Ms. Anderson, again, no, we did not. We relied on our counsel within the Attorney General's office within the state of Wyoming as they have the expertise in these.
Okay, but you said there weren't any state rules. So what were you interpreting and relying on to make that decision?
Ms. Anderson, the first couple things in there were of key importance to us as they pertain to this case are, was the property free and unencumbered? That's correct. The Attorney General's office made that review and relationship. Secondly, the Attorney General's office drafted our mortgage so that we were in first lien position for that valuation. And those are the pertinent items that we were considering.
But isn't the value pertinent, Mr. Wetland?
The value is provided by a certified, qualified, licensed appraiser in the state of Wyoming.
Okay. Before we get any further, you talked a little bit with Mr. Casti about that the appraisal was for the surface estate of the land, correct?
For the purposes of this valuation, it was made on the surface estate only.
Okay, but you talked a little bit about the mineral interest and how that also was granted to the DEQ through that mortgage.
The mortgage holds the mineral interest.
Are you aware of what mineral rights those are?
Ms. Anderson, I'm aware that there is coal, oil, and gas resources under this property.
And are you aware of whether those are fee minerals or federal or state or what the ownership of those mineral
Ms.
interests are?
Anderson, no, we did not go into that because it's not part of the valuation for the purposes of this collateral valuation.
So say the state takes over this property and there is a split estate question maybe for oil and gas. What happens then?
That's, Ms. Anderson, that's a theoretical question. And if it's federal minerals and it's split estate, typically it depends on whether there's a surface right or the exact mineral right and what those, my 30 years of experience, you would somehow go through a process for surface damages or mineral royalty. And that's not uncommon, but that's a theoretical question at this point in time.
Why is it theoretical if you don't know who owns those oil and gas resources?
Because
Sorry, Mr. Hearing Officer, I'm going to object in the instance in the hopes of shortchanging this exchange. Exhibit 4 of the mortgage says that it grants the interest that Contour owns. So there's no real question about BLM or anybody else owning those minerals. So we're kind of going down a irrelevant
Are we
route.
having trouble hearing? Yeah. Okay, so we're having trouble hearing. Just reminded everybody to speak up. Would you like to respond to that objection, counsel?
I would. That's actually not the case because if you don't know what mineral interests you owed, you have no idea whether they were granted to you. So the deed says that the mineral interests that were contained in the property were granted. But if someone else owns those mineral interests, like the federal government, they wouldn't be granted. In fact, as the council is aware, there's a lot of split estate land in this particular area, and it can be very pertinent to the value of the property and what the state can or can't do with it because of the surface estate and the need to accommodate through the development of minerals.
Okay, really, the other attorneys want to weigh in on this objection?
I'm happy with
Right, my inclination on this question is to allow the questioning to continue along these lines, time permitting. And you all can argue about the meaning of that exhibit when that time comes. So go ahead and ask. I don't know if there's a question pending, but go ahead, you may want to repeat.
Sure. I mean, Mr. Martin, the only question I have for you is whether you have any concerns about the state's interest, knowing that you have no idea who owns the mineral.
Again, Ms. Anderson, the valuation for the purposes of this bond were made on the surface estate.
Okay, thank you. Mr. Rutland, the next set of questions I have for you, you're going to walk me through what happens if the bond's forfeited, okay? Are you with me? You have to say yes for the record.
Yes.
Okay. I assume the first thing you would do is exercise that first and right lien mortgage that you and Mr. Casti were talking about, right?
Well, the first thing in the process is we have to go to the forfeiture proceeding with the council in order to move forward and pursue collections of the various security or financial assurance instruments that are on the table.
Okay. So you have to acquire title to this piece of property, right?
We have the first priority, first lien mortgage. We have the right to collect.
Okay, so you would go to the council, and then what would the council do?
Well, the council in any of our forfeiture proceedings presents an order to move forward with the forfeiture and collection. So that's when we would move forward with that.
Okay, and then you would try and sell the property, I presume?
Ms. Anderson, I don't know in that case whether the state would, certainly an evaluation would be made because there is the potential for that property to be used to offset an impacted landowner. That property may choose to be sold later in the forfeiture process. It would depend on where we are at in the forfeiture proceeding and the collection and need for that asset at the time. With the state having those interests, I think it would be prudent for the state to make an evaluation of when it would be best to liquidate that asset. Because there are surety bonds in excess of about $80 million here to move forward with the reclamation project up front.
So the state might end up holding on to this property, is that what you're saying?
Ms. Anderson, it's theoretically possible.
Okay.
Again, I would go back to, you have to understand how the bond's calculated. You have current disturbance plus 1 year. If they forfeit and go under in the first month, we have 11 months of accumulated asset. Does it make sense to liquidate that real property first or last? That's a decision that would have to be made at the time.
Okay, but it would be liquidated either first or last, presumably, right?
Presumably, if the need to complete the reclamation and that cash were there, yes.
Okay, that's what I'm getting at. Okay, so when you sell that property to liquidate it to get the amount needed for your reclamation work at the mine, what happens? How do you actually list the property? How do you sell it?
Ms. Anderson, that property would go through a standard sale process. You know, it would be put on the market for sale.
Okay, is the DEQ in the business of buying and selling real estate?
Ms. Anderson, no, it is not, but there are contingencies in the unknown contingencies, as we discussed earlier, that are available for those disposition of
Okay.
that property.
We'll get to those in a minute. So is because this mortgage is all about the DEQ, it's not about the state of Wyoming generally, right?
Ms. Anderson, the state of Wyoming and DEQ are one and the same.
Okay. So you're gonna sell this land, and I assume you'd have to hire a real estate agent or someone who, because again, DEQ isn't in the business, so you'd have to hire somebody, right?
Again, Ms. Anderson, that process is well known. We all know how property is sold, typically through an agent, through a broker. And there are unknown contingencies in this case to cover those expenses.
Okay, so DEQ would select a broker and you'd move forward with the process, presumably.
In theory, yes, or we may have a discussion with state lands on how best to dispose of that property because the state land department is in the business of dealing with that.
Okay, are this Office of State Lands mentioned in your rules at all?
No, it is not.
All right, and again, this is theoretical, but this is what this bond amount is about, which is why we're talking about it. Okay, so do you have an estimate for how much this will cost to hire this person that will help you sell this property?
Again, in my 30 years of experience on land acquisitions of this size, it's a 3 to 5% cost.
And you've bought or sold in those previous positions 40,000 acres of property before?
Yes, I've been involved in those acquisitions of that level, yes, for other companies.
Okay. All right, so let's go back to the bond amount specifically. And would you agree with me that your rules require you to set the bond amount at the difference between the fair market value of the property and any reasonable expense anticipated by the department in selling the property?
Ms. Anderson, that is how the rule reads, and that is probably accounted for that as previously stated in my testimony in the unknown contingencies.
Okay, but does that specific rule, does it talk about those unknown contingencies?
It simply says there needs to be a source for that differential, and that source is in those unknown contingencies.
Okay, well, let's get to those unknown contingencies. That's required of any bond, right?
That's correct.
Those unknown contingencies calculated before or after the company proposed to do real estate collateral bonding?
Ms. Anderson, they are calculated as a percentage of the total bond on all bonds.
Do you remember but you didn't really answer my question. So going back to that bond amount, was it set before or after the company chose to do real property collateral bond?
Ms. Anderson, I guess I'm not understanding your question because, again, those are unknown contingencies for unknown or unanticipated expenses. Cover that, and as we've stated in my prior testimony, even at a 10% rate, it would not consume but barely 50% of that valuation.
But Mr.
So that
Rutland,
valuation is there and it's accounted for.
but Mr. Rutland, again, these unknown contingencies are in any bond, right?
They are.
And aren't they more about whether, say you have to fill in a pit and that costs more than you thought it would, or, you move some trucks around and maybe that costs more than you thought
Ms.
it would?
Anderson, that is accounted for in the miscellaneous contingencies, and I would make the statement that in this case that a self-bonder may be in the same situation with these unknown contingencies where we're using them for some level of liquidation or recovery and some level of asset. So the items you're referring to are in the miscellaneous contingencies.
Okay, but would you agree with me that those unknown contingencies could be different if, say, the company held all third-party surety bonds versus a bond like this, where substantial part of it is a real property collateral bond?
Ms. Anderson, I'm not going to agree or disagree with you. I would say that every forfeiture is different, and the requirements for those unknown contingencies are different. And we may have with sureties or a case with multiple sureties where we may have unanticipated or scheduled legal expenses and recovery. So those are out there for those very reasons.
Okay, and it's just a flat 5%, right?
That's correct.
Okay, so doesn't your rule, go back to your rules, doesn't it say that you had to calculate the reasonable expense anticipated in selling the property?
3 to 5% would be 1 to 2, 1.2 to 1.6 million is contained in the unknown contingency.
Is there some documentation from you in email or when you made this decision about this 1 to 3%? Sorry.
3 to 5%.
Okay, it's 5% for the unknown contingencies altogether.
3 to 5% for liquidation of the property, if we had to liquidate.
Okay, so up to the full amount of these unknown contingencies could just be the real property bond component.
And Ms. Anderson, I'm not understanding your question.
Okay, this bond is more than just the real property collateral bonds, right? The real property collateral bond is only a portion of the total bond.
Yes,
So there's some third-party surety bonds too.
that's correct. As we discussed before in my prior testimony, that there's roughly $80 million because it's 118,026,700.
Okay. So that 5% that's in your bond amount, that covers everything, right? That whole 180 million.
Ms. Anderson, again, there are miscellaneous contingencies, as we discussed in my prior testimony, that are line itemed in the bond. And then there are the unknown contingencies. So
All right.
there are 2 levels there. And the unknown contingencies are 4 items like this liquidation of this asset.
But they're also for liquidation of surety interest, correct?
If necessary.
Okay, so you said that the real property collateral bond is up to 3 to 5%. The unknown miscellaneous contingencies are 5%. So say the real property collateral portion of that took that whole 5%, what's left for the liquidation of the sureties?
Ms. Anderson, that statement is inaccurate. You said the miscellaneous contingencies, so I guess I would ask for clarification of your question.
Okay, well, whatever we've been talking about, the unknown miscellaneous contingencies, correct?
Ms. Anderson, the unknown contingencies are 5% of that total bond. As we discussed in my prior testimony, 3 to 5% would be in the 1.2 to 1.6 million of the 4.6 million available. Even if you went at a rate of 10%, it would be 2.6, or at 50% of the roughly just right around 52% of the total unknown contingency balance.
Okay, is there anything else in that pot of 4.6 million that you would need that money for?
In theory, there may be.
Okay, and going back to
coverage there to account for that.
Okay, and going back just to the question I asked previously, so Mr. Mellon, are you aware whether that $4.6 million amount was set before or after Contura proposed to do real property collateral bond?
The 4.6 amount was calculated in the 2016 valuation of the bond.
And was that before or after the real property collateral bonds were accepted by the DEQ?
Ms. Anderson, it would have been in the process at the time. And again, I guess I'm not understanding your question because as in my prior testimony, I've said that is what those unknown contingencies are.
Okay, and so the 5% doesn't matter what type of bond it is?
Ms. Anderson, no, it doesn't. The 5% you're discussing is for the 5% of the cost for the reclamation, not on the sureties of the property.
Okay, thank you. That is my point exactly. All right, so let's go back to your rules. And do your rules talk about setting anticipated expenses for any other kind of bond?
Ms. Anderson, no, they do not.
So why do you think this is different? Why do you think the rules specifically talk about reasonable anticipated expenses for the department?
Ms. Anderson, the rules speak to that, and I believe the intent is to make sure that at some portion of the bond or calculation, there is adequate resources to liquidate this property if necessary. And as in my prior testimony, I have stated that is what the unknown contingencies are for, and there are adequate funds in that balance.
But again, you have no rules that says the unknown contingencies meet the requirements of this section.
Ms. Anderson, I guess I'm not understanding your question because I'm sure that it does.
Why?
I have already stated in my prior testimony that there is the unknown contingency balance is a 5% rating on the total bond, and those funds are available for disposition of this property if necessary.
Okay, so the unknown contingencies, is there a definition of that somewhere in your rules?
I can't speak to that today. I would have to research that.
And is there a definition in guideline 12 that you spoke to earlier?
Without, in order to speak accurately to that, I would have to see the document.
Okay, so can you speak today on whether it was envisioned by the DEQ that that unknown contingencies factor met the requirements of the regulation that require you to anticipate your reasonable expenses in buying and selling?
Ms. Anderson, the unknown contingencies are exactly that, for expected or unknown expenses that may occur if in any event. And as I responded to you earlier in my testimony, that was my understanding in writing Guideline 12 back in 1996 and being one of the original authors of it. That was put in there primarily at the time for self-bonders. If we did have to go after and liquidate collateral assets such as real property, such as buildings, such as rail spurs, it's exactly what that amount was put in there for.
Okay, but it's not in the rules as far as you're aware. There's not a regulatory definition
Not that.
of what that is. Okay. All right. So again, you didn't estimate any anticipated closing costs for the sale of this property?
Ms. Anderson, again, we said that they would be between 3% and 5%, and they would be contained within the contingencies if necessary.
Okay. All right, so I'm pulling up DQ Exhibit 14, and I'll let everyone find it. And Mr. Whitland, this was the map that you and Mr. Cassidy were talking about earlier, right?
Yes, that's correct.
Okay. And then the areas in green are the areas that have been, I guess, pledged to DEQ as collateral, lack of a better word, pledged to DEQ for collateral for these bonds, right?
That's correct.
Okay. Would you agree with me that there are two pieces of property used as collateral here?
Yes, that is correct.
Okay, and can you identify them on the map?
Yeah, their northern parcel is west of the Bel Air line, and the southern parcel is south, more adjacent or east of Wright and east of the rail line.
Okay, and without going into specifics of the appraisal, would you agree with me that these two pieces of property are fairly different in terms of location, size, value, use?
Ms. Anderson, I guess I'm going to ask a question of council here. Is that infringing on a portion of the?
You don't get to ask.
Well, Mr. Hearing Officer.
You don't get to ask.
Okay, Mr. Betlin, you have a
Just interpose an objection and maybe that'll clarify. Particularly the statement about value, I object to, is that Mr. Gray's expertise, he's not competent to answer a question about the value or use of these properties, nor is he familiar with the ranch properties. So maybe we want to parse those things out or ask something.
Okay, I will withdraw that question and we'll move on. So Mr. Betlin, again, you have a map in front of you. These ranches are at a different location, right? So there's two pieces, different location. One's in kind of mid Campbell County, one's in southern Campbell County, more or less.
Ms. Anderson, I don't know that I could make that distinction. They're roughly 15 miles apart in the center part of Campbell County.
Okay, but they are separated.
That is correct.
Okay.
They are physically disconnected.
Okay. Would you anticipate that you would need to split them up and sell them separately?
Ms. Anderson, I would assume that as in any property of disposition of this nature, that the whole ranch would be listed. And I'm sure there are, theoretically speaking, there are potential buyers that might want all or part of it.
Okay. So again, just to clarify for the record, you didn't separate out the anticipated reasonable expenses in selling the property separately for each parcel. You just kind of collectively did it for the total amount.
Ms. Anderson, that is, the whole ranch would be listed. that is how that disposition would go, and we would see where that went.
So you would list potentially Contour Wyoming Land, Bel Air Ranch, and the Black Thunder Ranch as one ranch?
That's correct, and it's not uncommon in Wyoming for ranches to be disconnected like this.
Okay. So, again, we're talking about 48,000 acres of real property, roughly, right? You have to say yes for the record. just to-
Yes, that's
Okay.
correct.
All right, what happens if you can't sell that much property?
Ms. Anderson, that's a theoretical question, and again, as prior testimony, I said the ranch would be listed in whole, and we would see if there were buyers for all or part.
All right, Mr. Rutland, but this is for the reclamation bond of your, of your permit here. So while it's theoretical, it actually has to work in practice. So what happens if you can't sell the property?
Ms. Anderson, in my 30 years of experience with a property of this nature, I do not believe that it would be unsellable.
Okay, but you didn't consider that possibility at all?
Ms. Anderson, again, I go back to, we have provided for the resources to liquidate this asset in the unknown contingencies, and I have no reason to believe that this asset would not sell. It is in a prime part of one of the best counties in Wyoming.
Okay, but what if you did have questions about the location? Again, I mean, you said earlier that you can't question the value of the property.
Ms. Anderson, I'm going to rely on my prior testimony. There's adequate funds to liquidate this property. It would likely be listed as an entire property and sold however that disposition transpires then.
Okay, and it would just be listed until it was sold.
Ms. Anderson, I don't know how else you sell property.
Okay, so what if it's listed 5 years and you need the reclamation money next week? What happens then?
Ms. Anderson, there are surety bonds in place to cover the initial expenses in the tune of roughly $80 million to start the reclamation process while this land would be in disposition or being liquidated.
Okay.
And again, if we go back and discuss the component of how the bond is calculated on current disturbance versus projected disturbance, some of those additional liquid assets would depend on what time of the calendar year or permit year, in this case, this particular bond were theoretically to go into forfeiture.
Okay. All right, so let's turn to some of these dates in these documents. So let's turn to DQ Exhibit 4, which is the mortgage document, and specifically page we can do the first page. Are you with me?
Yeah.
Okay. So would you agree with me that this mortgage is dated the fourth day of August 2016?
Yes, that is correct.
Okay. And the appraisal date is July 2017?
Yes. No, I'd have to look back to the appraisal. I don't know if we have that here. July 7th, 2017.
Okay. Are you aware of any other appraisals done for assessing the value of the collateral?
I didn't approve of any other appraisals for the purposes of this exercise.
Okay, so you're not aware of an appraisal that was done in 2016?
Again, I didn't approve I'd have to go back, but I didn't approve. The appraiser I approved was Mr. Brockman to conduct this appraisal, and that is the one of record.
Okay. But didn't Director Parfit accept the real property collateral bond as part of the permit transfer from Alpha to Contura back in September 2016, 9 months before that July 2017 date?
Go ahead and answer, and then I'm going to do an objection to this line of
Yeah,
questioning because what happened in 2016 is not an issue in this renewal or transfer permit proceeding,
Yeah.
but I'll fix it on redirect.
We join that objection.
Okay, so noted.
I guess I don't have that timeline in front of me, and therefore I would have to have clarification of them.
Okay, but just to clarify, you're not aware of any other appraisal for this property at issue?
There's not another appraisal that I authorized for this property. That I believe we would go back to the other exhibit of when I authorized that appraisal.
Okay. So let's turn to what happened since that July 2017 appraisal. Are you aware of any other appraisals done for assessing the value of the property since July 2017?
The only other appraisal that I have authorized is the
Okay. But wasn't that recertification done on Black Jewel's request, not Huntera's?
Ms. Anderson, again, as we have a license to mine and a subcontractor, and because these transfers haven't occurred, Ontura is still the owner of this property.
Okay, but let's turn to DEQ Exhibit 15. So we have a letter here from Keyhole Land Company to somebody who's a land manager, not testifying in this hearing, from Black Jewel LLC. So was this letter sent to Contura?
Ms. Anderson, I can't speak to that, but the recertification was for the land that has been proposed and is in question of the value, and I guess I'm not understanding where you're going with this.
Was it part of the permit renewal application and your consideration of that permit renewal application?
Ms. Anderson, this would be part of the renewal for Contura, and again, as we discussed earlier, and I had testified to the council, we have a subcontractor of Black Jewel at this time and a permit holder of Contura.
Right,
So-
and we talked a little bit about, because of the confidential nature of some of these documents, you would go to Contura and then Contura would go back to the appraisal, right? But this letter was given to CJ Fisk of Black Jewel. What's his relationship to the permit renewal application?
They are the subcontractor, essentially the license to mine operator for the mines at this point in time.
Has he seen the appraisal?
Mr. Fisk,
Yeah,
I can't speak to them.
okay. All right, let me ask Mr. Bachman about this letter a little bit too. Okay, so to clarify your response, did Contura, or anyone on behalf of Contura, representing that they were working for Contura, submit any evaluation of the value of the collateral as part of the application to renew the permit that you're aware of?
Ms. Anderson, the 2017 appraisal would have been what was submitted in the valuation for the renewal package coming into 2018. The value didn't change. The valuation has been recertified. I guess at this point in time, the department and the state have the first lien mortgage on that property for that value. And it meets the requirements of the collateral.
Are you aware of a part of your rules in Chapter 11, actually the old set of rules that we agreed earlier were relevant to the renewals, that talk about looking at the value of a property in a renewal application?
And
Right.
Ms. Anderson, that value has been looked at and it is unchanged.
But again, you're not aware of Contura submitting any physical document about that value as part of its renewal permit application.
Again, Ms. Anderson, as I prior testified, the valuation is the same and they are in the middle of this transfer, and there is the department and the state hold the first lien mortgage to this property for that amount and has the right to sell this property in the event there were a forfeiture.
Okay.
It is unquestionable.
Okay, Mr. Whitman, so we talked a little bit about this letter. It was filed as an exhibit. Was it actually part of any permit file? Where did you find this letter? And I assume you found it and you gave it to your counsel, so where was it in the DEQ files?
Assume as facts, not in evidence. Shouldn't assume things about me.
Sorry. Mr. Butland, did you collect this letter?
This letter was sent to me.
It was sent to you, okay. And when it was sent to you, what did you do with it?
It was sent as part of the bond package, and Ms. Wickman received it.
Okay, so it's part of the bond package for Black Jewel?
Part of the bond package for Contour and Black Jewel.
And Black
Because
Jewel. It matters,
because-
Mr. Whitman, which
Because there's
one.
a proposed transfer of those permits, Ms. Anderson.
So it's relevant, you're saying,
Ms. Anderson, the value of this property will transfer to Black Jewel upon completion of the permit transfers.
okay, but we heard in opening statements that that's actually not going to be the case. The Black Jewel's replacing the real property collateral bonds with something else, with surety bonds.
Ms. Anderson, I have no application at this point in time to rely on. That may be their intent, but I have no application to rely on for that at this time.
Okay. All right. So, Mr. Whitman, let's turn to that first lien mortgage that you and Mr. Cassidy were talking about. Did the department ensure that the property was unencumbered when it was submitted by Contura back in 2016 to be used as collateral for the reclamation bond?
Ms. Anderson, one question first. What exhibit are you moving back to?
This is Exhibit 4,
Thank you.
DEQ Exhibit 4. I should clarify. So did the department, are you ready for the question now? Okay, thank you. So did the department verify title information for this property?
Ms. Anderson, the property was transferred from Alpha to Contura, as we indicated, via a bankruptcy order. And yes, the Attorney General's office did review that and make sure it was unencumbered such that we could take first lien and first position on the mortgage.
All right, are you aware of the agreement between Campbell County and Black Jewel regarding Black Jewel's payment of delinquent mineral taxes? It was spoken to on opening statements.
Ms. Anderson, I'm aware of it. I'm not familiar with the document.
Okay. Was it relevant at all in your review of the property?
Ms. Anderson, that is a second position mortgage. The state of Wyoming and DEQ holds first position, so I am not concerned about that.
Okay.
And I believe in my prior testimony, I don't remember the particular page. Let me look here, but I believe it is stated in the mortgage in bold letters that we are in first position. I believe that's page 10, section 8.
Okay. So you talked a little bit about how the department maybe verified the title, working with the Attorney General's office, right? Did you also contract with an abstract office?
Ms. Anderson, no, I relied on the Attorney General's office and my counsel.
Okay, are you aware of your rules that these are the old rules? And for purposes, I have to find the original section here. So it's chapter 11 of the rules that were effective up to May 3rd, 2019. Section 3, little c, and then we go to Romanet 1, and then big C, big Roman numeral 1, little two dot, and I'll just read this for you. In the case of a fee simple interest, a title certificate, or similar evidence of title and encumbrances prepared by an abstract office authorized to transact business within the state is satisfactory to the administrator. Did you do that?
Ms. Anderson, it says satisfactory, and I relied on my counsel for that
Are they a-
determination.
Are they a title abstract company, your Attorney General's office?
Ms. Anderson, no, they are not, but they do represent legal counsel for the agency in my division.
Okay, so you didn't get a report from an abstract office authorized to transact business within the state?
Ms.
As part of
Anderson, as
this.
my testimony, I relied on the Attorney General's office and my counsel for that determination.
Okay. What information generally does the department require from the permit applicant to verify recording and perfection of the lien?
Ms. Anderson, as my prior testimony, I believe if we look in the mortgage and we go to the last page, it is verification of the recording with the appropriate county clerk.
Okay, so they bring back this filed and recorded mortgage to you and,
No, that's not correct.
okay.
The county clerk
that's fine too.
does the recording, and then we can see, and I believe it's fees were in the mortgage. My answer to your question would be on page 26, where it was received, recorded, abstracted, and indexed by the county clerk.
Right, but who gave you DQ Exhibit 4? The county clerk in Campbell County?
Yes, that's correct. You asked for that from the county clerk's office.
Okay, that's what I need to clarify. Okay, that's fine. All right, let's turn to the applicant violator system issue here.
Okay.
Okay, so I'm going to pull up our Exhibit 4. Are you with me?
Yes.
Have you seen this document before, Mr. Wetland?
Yes, I have. It was last updated, I believe, in about 1998.
Sure, that was my first year of college, right? It's been a while, but it's still what is relevant for permit transfers, correct?
It is a guidance document. It is by no means rule and regulation.
Okay, but it's the only guidance document DEQ currently has for permit transfers, right?
It is a document. The rules and regulations, if you go through the tracking of the requirements in certain portions of this SOP that were written, in 2009, there was a program amendment where much of this was adopted into the actual rules and regulations.
Okay, but Mr. Wetland, I got this document from your website. Are you aware that it's still on your website?
I am.
Okay.
And again, it was in 1998, and it's strictly a guidance document. It's not new anyway.
All right. Let's turn to page 6 of this document. Are you with me?
Yes, I am.
Okay. So I'm going to highlight a portion here. And on the screen, Mr. Wetland, can you see it back there? Do you need to make me, I want you to read it for me. So do I need to make it bigger? Probably need to make it bigger.
Can you just reference in the text here for me, please, what paragraph and where you are?
Okay, so it's, sure. So it's little b, that third paragraph, and the last sentence, starting with 3. Could you read that for me?
3 compliance checks must be conducted when the application is received, when it's deemed technically complete, and 3 days prior to approval.
Okay, are you aware is that department practice still?
In general, again, this is a guidance document, and as I testified prior, the one that counts is the one prior to the signature of the document.
Okay, but are you aware whether the department follows this guidance document? It is guidance related to permit transfers.
Ms. Anderson, it is general guidance, but it is exactly that, general guidance, and the document that counts is the one prior to signature.
Okay, but do you follow this document at all, is my question.
Ms. Anderson, I would say in general, yes, we do, because there were multiple ABS checks done.
So in general, but maybe not the specific dates.
Ms. Anderson, that's correct.
Okay, and you talked a little bit about with Mr. Cassidy about you can run these ABS checks at any time, right?
Ms. Anderson, that is correct.
Okay, but here we're talking about 3 specific checks.
Again, Ms. Anderson, that's referencing a general guidance that is not in rule and regulation. The one that counts, or the item that counts for the file of record, is the one prior to signature of the action by the agency.
Okay. So Mr. Rutland, let's go to the next paragraph in this guidance document. And who is the permit bonding analyst that this paragraph talks about in the agency right now? Is that person, do they have a job there?
As is referenced here, that would be Ms. Wickman and her bonding group.
Okay. And earlier you said that you're the one that instructs these applicant violator system checks.
Ms. Anderson, that's correct. Ms. Wickman and I generally coordinate on these.
Okay, and so you instruct Ms. Wickman to do the checks, or?
No, Ms. Wickman and I would discuss that, and I would ask for my staff that is the qualifications to be on the system to run that analysis.
Okay, we talked earlier, that's Ms. Romero, right?
That is correct.
Okay. Just note for the record, you might want to update your guidance. All right. So DEQ, and you have to do this check prior to permit issuance, right?
Ms. Anderson, that's, as I've testified prior, the final check that we do prior to signature is the one that counts for the record.
Okay, what happens if the permit applicant fails that check? What do you do?
That application will not be approved.
Is it denied?
Signature. It's not approved. It won't go through the process until they meet the conditional status of the ABS, as I prior testified.
So you keep running the ABS check at that time?
We would notify the applicant that they didn't pass, and then see if we can run a check in a future point in time and see if they will pass.
And is that future point in time somewhere in your regs on when you do that, how you do that, why you do that?
Ms. Anderson, it is not.
Council, if I can interject here, there's some people that have a lunch date, and I don't know if you have a natural break in your questioning.
Oh, I've got a while to go.
There we go. Do you want to break now?
Sure, that's fine.
Back to it?
Yeah.
Everybody will get to that?
No objection.
What time does everybody want to come back? 1 o'clock?
Yeah, I just know we're out in the middle of nowhere, but yeah, 1 o'clock should be okay.
1:30?
Yeah. Yeah. I mean, it'll take a half hour to get anywhere we need.
So let's go off the record.
Okay, thank you.
All right, so 1:30, you on back here.
Okay.
All right.